Welcome back to the Sunday Talk Show here on the Arise News channel. With me, I have Professor Bola Akintenwa, Director General, Bolitech Center for International Diplomacy and Strategic Studies, and Professor David Awurawa, Professor of International Relations and Strategic Studies at the University of Lagos. The Osun State Governorship Election Tribunal this past week voided the declaration of Senator Ademola Adeleke of the People's Democratic Party as winner of the July 16, 2022 governorship election in the state. The tribunal went ahead to declare Gboyega Oyetola of the All Progressives Congress winner of the election instead, after consideration of his petition against INEC's declaration of Senator Adeleke. Oyetola, who had served as governor since 2018, had asked the tribunal to nullify the election, hanging his case on alleged overvoting, infractions in some polling units, and the authenticity of the West African Examination Council certificate presented by the PDP candidate, among other grounds. In the meantime, Senator Adeleke described the tribunal ruling as a miscarriage of justice and vowed to challenge the ruling at the Court of Appeal. He faulted the resolution of the overvoting question in favor of Oyetola, calling it, and I quote, an unfair interpretation against the will of majority of voters, unquote. We're now being joined by two gentlemen, both of them lawyers, Toby Olagunju and Ashim Abioye, for a quick chat on this tribunal ruling and how it might affect governance and the political landscape in Ekiti State going forward. If I may just point out, Mr. Ashim Abioye is speaking for the Oyetola camp. He been counsel to Senator Ademola Jackson Adeleke. No, he been counsel to Alhaji Adegboyega Oyetola. And then I have with me in the studio Mr. Tomi Olagunju, who is speaking for the APC camp, the Adeleke camp. Gentlemen, thank you very much for joining us on this Day Live, the Sunday Talk Show.
Thank you very much, Dr. Abbott.
Can you hear me, Mr. Ashim Abioye? Hello, Mr. Ashim Abioye. Can you hear me from the studio here in Lagos? Hello, do we have a connection with Mr. Ashim Abioye?
I can hear you.
You can hear me. Very good. I was going to ask you, I wanted to start with you specifically. Now, the People's Democratic Party in Osun State, that is the Senator Ademola Jackson Adeleke's camp, is alleging and has made it very clear that the ruling of the tribunal was waybilled by the APC and waybilled by the APC, and that in any case, you know, that ruling cannot stand. And that the state chairman of that tribunal showed bias in his ruling. In fact, that he even showed personal animosity towards Senator Ademola Adeleke, even by referring to a line from Kiss Daniel's song, Lo 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 Bugawan, and all of that. What do you have to say in response to that? Because it's not just the PDP that is protesting. Other commentators have said, why should a judge descend to the level of singing a song in the course of a very serious matter? That's for you, Mr. Ashim Abioye. Hello, Mr. Abioye?
Yes, thank you very much for having me. Hello?
Hello, please go ahead. I just asked you a question.
Thank you very much. Thank you for having me. I think I will speak as a lawyer that participated in the proceeding throughout, from the beginning to the end. And I would say that the judgment of the tribunal was not a welcome one. And the use of language like miscarriage of justice, like that the tribunal chairman directed them and all that. These are languages that are welcome within the ambit of law. So it's not about condemning or attacking the personality of the judge. So
okay, Mr. Abioye, I'm not hearing you very well here in the studio. I thought the engineers said they contacted you and they tried to get very clear contact with you. But I'll come back to you. Let me come to Mr. Tobi Olagunju, who is here with me in the studio in Lagos, to comment on the same issues. And I hope that before long, your connection will be much better so that I can come back to you. Mr. Olagunju, over to you.
Thank you very much. To start from where you stopped with Mr. Abioye. It is not unusual in judgments to find judges making commentaries. In law, it is called obiter dictum. That is comments made on the side, comments made in person.
As opposed to ratio decidendi.
As opposed to the ratio decidendi. In this same judgment, the judge made several obiters. At page 150 of the judgment, you will find a reference to Things Fall Apart by Chinua Achebe. That is not part of the corpus of our laws, but you find it in the judgment. So, it is not out of place. It is not something we have not heard of before for a judge to make allusions to things that are outside the purview of law in their judgment. Shakespeare, Bible, Quran, music, a lot of things. Judgments themselves must make themselves easy to read. So if a judge makes allusions to things outside the ratio of the judgment, it does not in itself make it malicious or give credence to the fact that the judge had any personal animosity to any of the parties before him.
Well, another issue while we're still waiting for, okay, I understand that we now have Mr. Abioye with us. Mr. Abioye, I hope that your connection is much better now. If you may just continue from where you left off.
I can hear you.
Please go ahead.
I can hear you now.
Yes, please go ahead. I had asked you about the comment made by the PDP.
Hello, can I talk now?
Yes, please go ahead.
Thank you very much. As I was saying, as a lawyer that participated in the entire proceeding, I would say that the judgment did not represent the evidence that was before the tribunal. The judgment of the tribunal, I would say the judgment delivered by the chairman of the tribunal was focused on a beaver's report. And this misconception we must clear is that it was a judgment against the beaver's machine. It was a judgment against the deployment of the beaver's machine. It was a judgment against the deployment of technology in our electoral process, which has changed the game. So, and you see that there has been a campaign against the beaver's machine. So, and if the judgment is allowed to stay, it will rubbish the innovation, the development in our electoral system. What I'm saying in essence is that the APC filed a petition and premised it on a beaver's report obtained from the server, not from the beaver's machine itself. They applied for a certified true copy of the beaver's report, and the beaver's report was given to them, the beaver's report that was given to them was printed from the server. And when they used that to file their petition, and when they filed their petition and we got that, we had to apply to INEC as well for a certified true copy of the beaver's report. And we got a different beaver's report. It was printed from the server as well. So making it that there were two reports from the server that we got from INEC. So the best we could do in the circumstance was to ask INEC and to place before the tribunal the beaver's machines themselves, which we actually did. And we for the second respondent, that's Senator Adebola Jackson Nurudeen Adeleke, applied to the tribunal for an order to allow us inspect the beavers machines physically to extract data from them, and the tribunal granted that order. That order of inspection which the tribunal granted, by virtue of that, we were able to conduct physical inspection of the beavers machines, and we were able to extract data from the beavers machine, physical data that was not of a species of the beavers report and the beavers report upon which the petitioners premised their petition. What I'm saying in essence is that while the beavers report upon which the petitioners premised their petition was from the server, and the second one which INEC issued when we applied upon seeing their petition was also from the server, but upon physical inspection of the beavers machines, we extracted directly from the beavers machines, and the reports gotten therefrom was placed before the tribunal. And apart from that, the beavers machines themselves in the challenge 749 polling unit were placed before the tribunal. In the circumstance, the beavers machines themselves were the source document.
Okay, we seem to have lost connection there, but he was talking about the beavers, machine. Well, Mr. Olagunju, your camp, the APC, the PDP camp is saying that that ruling was meant to discredit the beavers machine. And that's the argument that he was advancing there.
I think the opposite is actually the truth. That judgment is a validation of the work of the beavers machine. What the judgment simply says is that you have deployed technology in the management of an election. In the prosecution of an election, you have deployed technology. If you have to stay within the confines of the technology that you have deployed. This is the situation, Dr. Abati. The candidate of the APC applied to the Independent National Electoral Commission after the election. Please oblige me with a copy of the report of all your beavers machines. Don't forget, the new law says that, the new electoral law, the 2022 electoral law says that for you to vote, you must be accredited by the machine provided by INEC. Beavers machines were deployed, and it is bimodal. It accredits you either with your thumbprint or your face. Once you are accredited by that machine, the machine ticks you as accredited. This is against the previous situation where it is the presiding officer that ticks you on the voters register that you have been accredited. After this, the information on the beavers machine is transmitted to the storage facility of INEC. That is where this report was retrieved. It was given to the petitioner, Alhaji Gboyega Oyetola. It is from this that the issues of overvoting were discovered. After that, INEC produced another one. One of the respondents produced another one. What the tribunal found about these two subsequent reports was that they run riot, and I'm quoting the tribunal now, they run riot to the defense presented by the respondents themselves. What it meant was that the reports that they themselves brought ran riot, was at variance with the defense they were presenting before the court. What INEC, for instance, came to the court to say was that it was not synchronized at the point that they were issuing the reports to the petitioner. The question was, did you state it at that point that it was inchoate? Did you state that it was incomplete? The witness of INEC himself said, I did not say it was incomplete. And the court regarded that as an admission of the fact that the beavers report issued to the petitioner was correct, and that all subsequent actions thereafter amounted to tampering with official documents. To me, it is a plus for the beavers machine, in the sense that technology doesn't have a mind, technology is not biased, technology will show you exactly how it is. Technology was deployed, it will have been impossible to detect the anomalies in the election without the deployment of technology and beavers. So rather than being an indictment on the beavers machine, it is kudos to it. It is beavers machine that has been able to resolve the debacle in the July 16 election of Osun State.
Okay, but one of the claims made by Senator Adeleke in his broadcast was that there was no majority judgment. This was a 3-man panel. In the various reports that I have seen, we were told that it was a decision 2-1. The chairman of the tribunal read the lead judgment, and there was a dissenting judgment. But the governor in his broadcast said there was no majority judgment. How is that possible in a panel of 3?
There's clearly a majority judgment, and there's a dissenting judgment. If I wanted to be as simplistic as they appear to be in this matter, I would just have advised them, don't appeal. Since there's no majority judgment, leave it. If I wanted to be that simple, I would just say, since you believe there is no majority judgment, then there cannot be a judgment against you, speaking in that sense. So leave it and don't appeal it. But in actual fact, there is a majority judgment. It is, they are equating it with the appellate courts where each judge delivers separate judgments. In this case, the majority judgment was signed by the 2 judges that concurred that there was overvoting in the July 16 gubernatorial election in Osun State. The dissenting judge gave a dissenting opinion, which for all intents and purposes is an opinion. In a tribunal, the judgment of the tribunal is the judgment of the majority. A minority judgment is what it is, a dissenting opinion given by the judge who has not been able to agree with the majority. That is why you find that in election tribunals, you have odd numbers. It is because it is possible that a section of the tribunal will not agree with the majority. Every judge must take a position. In this situation, 2 of the judges took the position that there was indeed overvoting, properly proved before the tribunal, and nullified the return of Senator Jackson Adeleke, and directed that the person with the highest lawful votes is Alhaji Abioye. So if the governor has been advised that there is indeed no judgment, then perhaps he should forget it and not appeal.
Yeah, but one of the things that the APC is saying is that the PDP is saying is that this will have implications for the general elections, and that the target is not just the Osun governorship election of July 2022, but the general election scheduled for February-March 2023. Do you see the connection?
I've always seen a connection between whatever is decided in this tribunal and the general election, not the way the PDP sees it though. I don't know how they have brought about their own nexus between what will happen at the general election and what has happened at the tribunal in Osun. If the tribunal in Osun had permitted beavers to be violated in the sense that the respondents have urged on the tribunal, then we shouldn't even bother about the general election in February. And I'll tell you why, Dr. Abati. The reason is because technology has been brought into the game now. Everybody knows that unless you are accredited by that technology, you are not eligible to vote. What this means is that it is very easy to track overvoting. If the argument of my learned friend, Mr. Hashim, for instance, is to be believed, what it means is that the back-end server of INEC, they can produce a report. These are the number of people who have been accredited. And then the actual figures on the field will run riot to it. It will be at variance with it. How do we reconcile the vagaries? So in my view, the report, the judgment of the Tribunal of Osun upheld the sanctity of the process devised by INEC. And I think it's a victory for INEC more than anybody, and a testimonial to the innovations of the National Assembly by the Electoral Act 2022.
Okay, I understand that Mr. Abioye is back with us. Mr. Abioye, if you can hear me, good to have you back, because we want to make this a balanced conversation on both sides. Are you there, Mr. Abioye? Can you hear me now? Hello, Mr. Abioye.
Yes.
Yeah, it looks like I don't know whether you are in the village or in the middle of nowhere why your connection is so poor. But I mean, the gentleman here, Mr. Olagunju, has tried to respond to the issue of beavers. And he has also responded to the point about there being no majority judgment, which Senator Adeleke pointed out in his statement. And then you had written to INEC to tell INEC not to give the certificate of return to former Governor Oyetola. If you could take us through all those details, if you can hear me. Hello, Mr. Abioye. Can you hear me? Hello, Mr. Abioye.
What he said was quite right. Yes, hello.
I can hear you. Go ahead.
I can hear you. What I'm saying, yes, I can hear you. I heard your question. I'm responding.
Please go ahead.
Hello?
Please go ahead.
Yes, thank you very much. You see, what His Excellency said was quite right. The Apex Court, in several decisions, even of late, we had one in 2022, had expressed
Hello, are you there, Mr. Abioye? Okay, looks like that connection is really bad. I think at this point, I just give up. Let me come back to you. Is this a case of history repeating itself? Because that's one question that I've seen somewhere. In 2010, it was Oyinlola versus Aregbesola, and the whole issue was about recalibration of the number of votes on this side, on that side, and the same thing has happened this time around. Do you think this is a case of history repeating itself?
Not in any way. The issue of accreditation and voting has always been a very big one in electoral disputes. Therefore, if you find 10 electoral disputes, you are going to find at least 9 or 8 linked to accreditation and voting, which are the two basic duties of electorates on the election day. This case is novel. Novel in the sense that this is the first time INEC is deploying technology that is backed by law. Don't forget, Dr. Abati, that before now, there was what INEC used to call the card readers. But if you are not accredited by the card reader, there's something called the incident form. In which case, I cannot get accredited because the card reader cannot recognize my fingerprint. You fill an incident form and vote. Even when they said you can no longer use incident forms, courts did not give effect to reports from the card reader because it was not backed by law. The novelty of the situation in the Osun case is that this is the first time that a tribunal will look at the effect of technology backed by law. It would have been different if this case had happened in 2018. The petitioner would not have been able to rely on the Beavers report. He would not have been able to rely on data generated from the technology deployed by INEC. In this situation, the law says, unless you are accredited, you cannot vote. The implication is that it gives a zero margin of error. Unless you are accredited, you cannot vote. It is a technology that will accredit you and state that you have been accredited. So in a situation where 200 people get accredited and you have 260 people voting, that is a clear case of overvoting. The implication is that some people voted without going through the process of accreditation. The implication of that by law is that such result from such polling units will be cancelled.
But what do you say to the letter by Abioye to INEC, advising INEC not to give a letter of return to a certificate of return to the candidate of the All Progressives Congress?
I believe it's just dancing to the gallery. The governor
they say they are going on appeal.
Yes, because
all the way to the Supreme Court.
Yes, the governor.
And they say they are determined to win this case.
Oh, beautiful. It is going to help our electoral jurisprudence. All I am saying is that you have a window of 21 days to appeal. Within that 21 days, your governorship is not to be disturbed by law. So whether or not you write the letter, no other person will be sworn in except you do not appeal within 21 days. So writing to INEC, they know why they have done that. But to me, it appears that that is plain to the gallery.
Okay, what do you think are the key lessons that we can take away from this particular ruling? Because INEC, before now, used to tout the Osun election, for example, to cite just that specific example, as an indication that the innovation in the Electoral Act 2022 with regard to the deployment of technology is working. And the INEC chairman has also had cause to point out that for the general elections, February, March, they've had significant experience in Anambra and in Osun. And now we have this, can I use the word crisis with Osun?
There is no crisis. In fact, it is a vindication of what the INEC chair has said. You have deployed technology. What is invisible to the eye? If Dr. Adbati had been an observer there, he perhaps may not have seen this overvoting. Technology will detect. So to me, INEC has done well. It should learn on how to, perfect its procedures for the general election. But this decision of the tribunal has in no way implicated the procedures of INEC or the technology that INEC has deployed. It may have implicated certain personnel of INEC. For instance, people who the tribunal found have tampered with official documents after it had been issued to one of the parties, or people who allowed voting to continue late into the night without proper accreditation. This judgment may have indicted those ones. But as for the procedure of INEC and the technology that it has deployed, I think this judgment has vindicated that procedure.
Okay, it's unfortunate that the internet connection for the lawyer for the People's Democratic Party is poor, but I'm sure we'll get another opportunity to speak with them. Is he back again? I hope he's been able to get it right now. Mr. Abioye, are you there? Is your internet now working? Wherever you are. Hello, can you hear me?
I think I'm okay now.
Okay, please go ahead. On those issues I asked
Hello?
you earlier on. Yes, please go ahead.
Thank you very much. What I was saying earlier on was that the judgment of the tribunal was directly against the beavers machines, and the beavers machines had not done anything wrong in the circumstance because the beavers machines were properly placed before the tribunal, and the data on them contained the information captured at all the polling units being challenged on the day of the election with the date and the time. The problem was with the beavers reports from the server. And what we are talking about here is that you cannot determine overvoting on the basis of the materials that were not present at the polling unit. You can only determine overvoting on the basis of the physical materials at the polling unit, which were the beavers machines themselves, the electoral forms, and the voters register. The introduction of beavers machines or any technological device by INEC has not obviated the use of voters register. So both go pari passu in accreditation. So what happened in Osun was not the issue of overvoting at all. What actually happened was that there was a tampering with the server reports, not with the server, with INEC server, not with the beavers machine themselves. They got a report from the server, which they used in filing their petition. We got another report from the server as well. And when we discovered that the two reports from the same source were not the same as a result of technological hitches, we had to apply to the tribunal, and the tribunal granted us an order to inspect the beavers machines physically. And we brought the beavers machines and placed them before the tribunal. As well, we extracted information directly from the server, from the beavers machines, and we placed them before the tribunal. So what we are saying is that the tribunal was faced with a controversial secondary source and a non-controversial primary source. And we all know that in analyzing data, or if you want to establish a fact, you go to the primary source. Since the information before the tribunal, upon which the petitioners premised their petition, the pillar of their case was on a server report, and there was another server report, not the actual beavers machine. The best evidence in the circumstance was the beavers machines that were placed before the tribunal, and the information extracted from them based on the order of the tribunal, which the tribunal admitted in evidence, and the tribunal never rejected the beavers machines, and the information extracted from them, the tribunal never rejected them in evidence. But the chairman of the tribunal closed his eyes against the pieces of evidence that were uncontroverted, that were unchallenged, that is the beavers machines themselves. So it's a matter of recourse to a controversial secondary source and to prefer it over and above a primary source that was not controversial at all. So that the tribunal, the Court of Appeal will sort out whether a secondary source can have preference and superiority over and above a primary source that was serenely placed before the tribunal unchallenged.
Well,
another issue is about the judgment read by the tribunal chairman, which His Excellency Senator Ademola Adeleke rightly informed the whole world that there was no majority judgment. His Excellency was right, because if you are writing a judgment as a panel, each member of the panel must reduce his judgment in writing individually. You don't co-sign a judgment and call it a judgment. A tribunal that sits as a panel cannot co-sign a judgment, and a tribunal that sits as a panel cannot co-sign a judgment and call it a judgment. You must reduce your writing, your opinion, and you must reduce your opinions into writing individually. And that's what the Supreme Court decided in Inyesom Wike's case against Peter Side. The same thing the Supreme Court decided in NASCO against Bello. So authorities are there, and these are not authorities of the Mungo Park era. Hello?
I'm with you.
Hello, hope I have the connection.
I'm with you. I can hear you, but Mr. Olagunju here. Yes, I can hear you if you can hear me. Mr. Olagunju here seems to think differently. He says you are confusing an election petition tribunal with a court of appeal, and that an election petition tribunal does not function like a court of appeal. What do you say to that? Hello? Are you there?
Yes. I want to refer Mr. Olagunju, with all due respect, to the case of NASCO and Bello. It's a 2020 decision.
Okay, I heard that. But I was going to ask you another question. Another thing that Mr. Olagunju said was that...
You should also read the decision. Mr. Olagunju, with all due respect to those decisions. Hello?
Yes, I can hear you. Go ahead.
Mr. Olagunju, with all due respect, go and read that decision. It should start from the decision of Inyesom Wike and Peter Side, where the Supreme Court, said it applies to any court or any tribunal sitting as a panel that each member of the tribunal must reduce his opinion in writing individually. You don't co-sign a judgment and...
Okay, while we try to re-establish connection with you, what do you say to that? He just gave you case law on this subject.
My simple advice to him is, if he feels there's no judgment, he should not bother to appeal. It's very simple. That's my advice to Mr. Abioye. Advise your principal that there's no majority judgment, so there's no basis for any appeal. Or would you appeal a non-existent decision? So that after 21 days, the repercussions will show. I think we should stop it at that point. If you say, for example, this is not the first time the parties are meeting in an election petition. They met in 2018. There was a decision, majority and minority. How was it signed? How was it presented? So my view simply is that if Mr. Ashim Abioye and the eminent panel of senior advocates that they have on their side feel that there is really nothing to challenge, because what they are simply saying is that there is no majority decision. That means there's a stalemate. The panel has not come out with any clear-cut decision. So it's better to leave it unattended to, leave it unappealed. In my view, that tribunal has reached a valid decision by a majority of 2-1, and the only way to reverse it is by an appellate process.
Okay, Mr. Abioye, are you there? Are you listening to this?
Yeah.
Okay.
Yes, by way of short response, the tribunal is now functus officio, and that is why we are going on appeal. It's just one of the issues that the Court of Appeal will trash out, whether in act.
Hello, Mr. Abioye. Are you still there? Are you still there?
And that's why we are going on appeal.
Okay, but I wanted you to respond to something.
Whether a co-signed judgment by a panel.
Okay, well, Mr. Abioye, I wanted you to respond to the point made by Mr. Olagunju here, that the letter you wrote to INEC is of no moment, completely.
Hello?
Yes.
Hello?
Yes, I can hear you now. If you may just please summarize. Yes, please go ahead. Hello? Okay, well, looks like we lost that connection again, but the whole idea is to have a balanced conversation, listening to both sides, the PDP side and the APC side in the Osun matter. At this point, I would like to thank both of you, gentlemen, Mr. Tobi Olagunju and Mr. Ashim Abioye. Excuse me?
Tomi Olagunju is my name.
Tobi Olagunju?
Yes, Dr.
Okay,
Martin.
I don't know how, they got that wrong. Okay,
Thank you
very much, Mr. Tomi Olagunju.
Thank you very
much. And Mr. Ashim Abioye for joining us.